Hi, you have a deposition coming up. I thought it made sense for us to get ready for it, and this is probably the most efficient way. 3 major rules for your deposition. Number 1, tell the truth. Number 2, answer only the question that's being asked. Number 3, if you don't know an answer, can't remember an answer, or you're not sure, say those things. I don't remember. I'm not sure. I can't recall. That's just fine. In many ways, your deposition is like a test, but it's a test of what kind of witness you'll make. It's not a test like you take in school. In school, we're encouraged, if it's a multiple choice test, to make sure to fill in an answer. Maybe we'll get lucky and it'll be the right answer. Same thing with an essay test. We're always told, write something down, maybe you'll get partial credit. Well, the deposition is not like that. If you're not sure, just say I'm not sure. It's just fine. The deposition will take place in a room like this. Albeit the deposition, there will be a court reporter. The court reporter takes down everything that's said. Opposing counsel will be there and will ask questions. It may be that the defendant's there and/or a representative of the defendant's insurance company. During the deposition, we can take breaks anytime you want. The only exception to that rule is when there's a question pending. If there's a question posed to you, you need to answer it before asking for a break. But after you answer it, we can break and talk about whatever you want. Okay, so when I was introducing the idea of the deposition and the 3 rules, I mentioned answer only the question that's being asked, and that was the second rule. I like to think of it as being similar to dealing with law enforcement or going through the border. It's particularly like going through the border. So, I suspect most of you, or you, because I'm only talking to one person, have gone through the border into Canada. You pull up in your car, you roll down the window, the man or woman in the booth says citizenship, and you say US. You say, where are you going? And you say Vancouver. Where are you staying? Well, I'm staying at the Pan Pacific Hotel. How long are you going to be there? 2 nights. Do you have any fruits or vegetables in the car? No. Do you have over $10,000 cash? No. And they'll say, have a great time in Vancouver. So that's the way you want to handle your deposition. You don't want to say, I'm staying at the Pan Pacific and I negotiated this really great rate, and with the extra money, we plan on buying a live doe. Because we understand that Vancouver is a very herb-friendly city. No reason to say that, just say Pan Pacific. Same thing during your deposition. You may be asked a series of insipid questions, questions that don't elicit information about the case and really aren't relevant. That's fine. Answer them one by one. Provide your answer, be quiet, wait for the next question. During depositions, there are a different set of rules that apply than at trial. You've seen trial on TV, maybe you've been to a trial. At trial, you'll hear lots of objections. The attorneys will say, objection, relevance, and the judge will rule. Well, the deposition is different. There are no relevance objections. Similarly, there are no hearsay objections. And there's no judge to rule. You may hear objections like objection, form, compound. And that means that 2 questions have been rolled into one. After you hear that objection, if you understand the question, go ahead and answer it. If you don't understand the question, don't answer it. There's no judge there to rule on the objection. So the flow of the deposition continues. No reason to look to me like, should I answer that? Yeah, you should answer that. No reason not to. The only time you wouldn't answer a question during a deposition is if it invokes the attorney-client privilege. And I will make that abundantly clear that you shouldn't answer. It'll sound like this. So, Mr. Smith, what did you do to get ready for your deposition? And Mr. Smith will say, well, I reviewed my discovery responses and I met with Mr. Myers. When did you meet with Mr. Myers? Yesterday. What did you and Mr. Myers discuss? At that point, I'll say, objection, attorney-client privilege. Mr. Smith, don't answer the question. And unless you hear those words come out of my mouth, don't answer the question. I want you to answer the question. And it doesn't matter what the question is. Maybe in your claim, you're claiming bad injuries have affected your sex life with your husband or your wife. And opposing counsel will want to ask how often you had sex before the accident. I want you to say 2.5 times a week. Opposing counsel may say, what qualifies as half a time? Well, go ahead and tell them what qualifies as a half a time. You said 2.5 times, you tell them. There's really nothing that's out of bounds at a deposition. And we give the best information to the defense if we treat it that way. If we don't get nervous, if we don't get angry, if we don't argue, if we just answer the questions and we get through it, here's what we're telling the defense. We're telling the defense that you're a good witness. We're telling the defense that you don't need me to prop you up. We're telling the defense that we're ready to go to trial, and when we get to trial, the jury's going to like you because you don't hem, you don't haw, you don't offer superfluous information, you don't look to me for support, you just answer the questions. The only things you need to remember at the deposition, by and large: 1, how you felt before the accident; 2, how the accident happened; and 3, how you feel now. It's not a test of memory, other than those 3 things. Maybe you're asked what kind of grades you got in algebra in 8th grade. Peculiar question, probably doesn't help the defense. If you remember, I got an A- the first semester and did a lot better, I got an A the second, say it. If you don't remember, say I don't remember. If you're asked, how many times did you see the chiropractor? Well, if you're really a student of your treatment records, you can say 43 times. That's great. If you know it, if you say somewhere between 20 and 40 times, that's fine too. Because we're not relying on you to be able to itemize each and every appointment you have with your chiropractor and testify how much was charged and how much was paid by your insurance company, etc. All of that information is memorialized in your treatment and billing records. So again, the only things we really need for you to know and to express clearly during your deposition: how you felt before the accident, how the accident happened, how you're doing now. If you have any additional questions, let me know. I'm happy to go over them with you. I think this video covers really most of the high points for your deposition. And if you follow those 3 main rules: tell the truth, answer only the question that's being asked, and 3, if you don't know an answer, say I don't know it. If you follow those rules, you'll do really well.